Ladies and gentlemen, I'll now give you the charge of the court. It's a somewhat lengthy document. It's going to take me several minutes to read it to you, and you're welcome to take notes while I read it to you. But I also want you to know that each of you is going to get a copy of this document for your use during the deliberations as well. Ladies and gentlemen, you're considering the case of the state of Georgia versus Tiffany Nicole Moss. The grand jury has indicted the defendant with the offenses of 1 count of murder, 2 counts of felony murder, 2 counts of cruelty to children first degree, and 1 count of concealing the death of another. The indictment reads as follows. Count 1. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Tiffany Nicole Moss with the offense of murder. For it the said accused in the county and state aforesaid between the 24th day of October 2013 and the 2nd day of November 2013, the exact date of the offense being unknown to the grand jury, did then and there unlawfully and with malice aforethought cause the death of Amani Gabriella Moss, a human being, by withholding sustenance necessary to sustain human life, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 2. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Tiffany Nicole Moss with the offense of felony murder. For it the said accused in the county and state aforesaid between the 24th day of October 2013 and the 2nd day of November 2013, the exact date of the offense being unknown to the grand jury, did then and there unlawfully, while in the commission of a felony, to wit, cruelty to children first degree, cause the death of Amani Gabriella Moss, a human being, as alleged in count 4 of this indictment, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 3. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Tiffany Nicole Moss with the offense of felony murder. For it the said accused in the county and state aforesaid between the 24th day of October 2013 and the 2nd day of November 2013, the exact date of the offense being unknown to the grand jury, did then and there unlawfully, while in the commission of a felony, to wit, cruelty to children first degree, caused the death of Amani Gabriella Moss, a human being, as alleged in count 5 of this indictment, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Tiffany Nicole Moss with the offense of cruelty to children first degree. For it the said accused in the county and state aforesaid between the 24th day of October 2013 and the 2nd day of November 2013, the exact date of the offense being unknown to the grand jury, did then and there unlawfully and maliciously cause Amani Gabriella Moss, a child under the age of 18 years, cruel and excessive physical and mental pain by withholding necessary sustenance to sustain human life, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 5. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Tiffany Nicole Moss with the offense of cruelty to children first degree. For it the said accused in the county and state aforesaid between the 24th day of October 2013 and the 2nd day of November 2013, the exact date of the offense being unknown to the grand jury, did then and there unlawfully, being a parent of Amani Gabriella Moss, a child under the age of 18 years, willfully deprive said child of necessary sustenance, to wit, food and water necessary to sustain human life, to the extent that the child's well-being was jeopardized, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 6. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Tiffany Nicole Moss with the offense of concealing the death of another. For it the said accused in the county and state aforesaid between the 24th day of October 2013 and the 2nd day of November 2013, the exact date of the offense being unknown to the grand jury, did conceal the death of another, to wit, Amani Gabriella Moss, and did thereby hinder the discovery of whether such person was lawfully killed, contrary to the laws of said state, the good order, peace, and dignity thereof. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the parties, or questions asked by the parties. Every citizen has the constitutional right to represent themselves should they choose to do so. In this case, the defendant has chosen to exercise that right and has chosen to represent herself. Nothing regarding the defendant's choice to exercise her constitutional right to represent herself shall be construed either for or against the defendant or for or against the state. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is a proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight that you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pre-trial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. In assessing the credibility of a witness, you may consider any possible motive in testifying if shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of the witnesses. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness provided you find the evidence to be sufficient. An exception to this rule is made in the case of murder, felony murder, cruelty to children first degree, and concealing the death of another, where the witness is an accomplice. The testimony of the accomplice alone is not sufficient to warrant a conviction. The accomplice testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the inference of the guilt of the accused independent of the testimony of the accomplice. It is not required that supporting evidence be sufficient to warrant a conviction or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The sufficiency of the supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is a question for you to determine from the evidence in this case. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose. Such evidence may be considered by the jury for the sole issue or purpose for which the evidence is limited and not for any other purpose. In order to prove its case, the state must show intent and must negate or disprove accident or mistake and may show motive. To do so, the state has offered evidence of other crimes, wrongs, or acts allegedly committed by the accused. You are permitted to consider that evidence only insofar as it may relate to those issues and not for any other purpose. You may not infer from such evidence that the defendant is of a character that would commit such crimes. The evidence may be considered only to the extent that it may show the issues that the state is required or authorized to prove in the crimes charged in the case now on trial. Such evidence, if any, may not be considered by you for any other purpose. The defendant is on trial for the offenses charged in this bill of indictment only and not for any other acts, even though such acts may incidentally be criminal and may have resulted in conviction. Before you may consider any other alleged acts for the limited purposes stated, you must first determine whether it is more likely than not that the accused committed the other alleged acts. If so, you must then determine whether the acts shed any light on the elements of the offense or issues for which the act was admitted in the crimes charged in the indictment in this trial. Remember to keep in mind the limited use and the prohibited use of this evidence about other acts of the defendant. By giving this instruction, the court in no way suggests to you that the defendant has or has not committed any other acts, nor whether such acts, if committed, prove anything. That is solely a matter for your determination. Evidence of prior difficulties or lack thereof between the defendant and the alleged victim has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victim and the reasonableness of any alleged fears by the alleged victim. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. You have received in evidence a prior conviction of a witness. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness and not for any other purpose. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person A, directly commits the crime, B, intentionally helps in the commission of the crime, or C, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. Any party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crimes of murder, felony murder, cruelty to children in the first degree, and concealing the death of another were being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crimes must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that the crimes were being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of the alleged offenses, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crimes of murder, felony murder, cruelty to children in the first degree, and concealing the death of another were being committed, and that the defendant knowingly and intentionally participated or helped in the commission of them, then you would be authorized to convict the defendant. A person commits murder when that person unlawfully and with malice aforethought, either expressed or implied, causes the death of another human being. Express malice is that deliberate intention unlawfully to take away the life of another human being, which is shown by external circumstances capable of proof. Malice may, but need not, be implied when no considerable provocation appears and when all of the circumstances of the killing show an abandoned and malignant heart. It is for the jury to decide whether or not the facts and circumstances of this case show malice. To constitute murder, the homicide must have been committed with malice. Legal malice is not necessarily ill will or hatred, but it is the unlawful intention to kill without justification, excuse, or mitigation. If a killing is done with malice, no matter how short a time the malicious intent may have existed, such killing constitutes murder. Georgia law does not require premeditation, and no particular length of time is required for malice to be generated in the mind of a person. It may be formed in a moment, and instantaneously a mortal wound may be inflicted. Yet, if malice is in the mind of the accused at the time of the doing of the act or killing and moves the accused to do it, such is sufficient to constitute the homicide as murder. Proof of a particular motive is not essential to constitute the crime of murder. Evidence of motive, if any, is admitted for your determination as to whether or not it establishes the state of the defendant's mind at the time of the alleged homicide. A person also commits the crime of murder when, in the commission of a felony, that person causes the death of another human being with or without malice. Under the laws of Georgia, cruelty to children first degree is a felony and is defined as follows. Any person commits the offense of cruelty to children in the first degree when that person maliciously causes a child under the age of 18 cruel or excessive physical or mental pain. Malice is not ill will or hatred. For the purpose of this code section, malice means an actual intent to cause the particular harm produced that is physical and mental pain without justification or excuse. Malice is also the wanton and willful doing of an act with an awareness of a plain and strong likelihood that such particular harm may result. Intention may be shown by the circumstances connected with the offense. A parent of a child under the age of 18 commits the offense of cruelty to children in the first degree when that person willfully deprives the child of necessary sustenance to the extent that the child's health or well-being is jeopardized. I instruct you that sustenance is food and drink which is sufficient to support life and maintain health. If you find and believe beyond a reasonable doubt under all the evidence and the court's instructions that the defendant is guilty of the offense of murder with malice aforethought, then you would specify such in your verdict, and the form of your verdict in that event would be, we, the jury, find the defendant guilty of malice murder. If you find and believe beyond a reasonable doubt under all the evidence and the court's instructions that the defendant is guilty of the offense of felony murder, then you must specify such in your verdict, and the form of your verdict in that event would be, we, the jury, find the defendant guilty of felony murder. If you find and believe beyond a reasonable doubt that the defendant committed the homicide alleged in this bill of indictment at the time that the defendant was engaged in the commission of the felony of cruelty to children first degree, then you would be authorized to find the defendant guilty of murder, whether the homicide was intended or not. Cruelty to children first degree has been previously defined for you. In order for a homicide to have been done in the commission of this particular felony, there must be some connection between the felony and the homicide. The homicide must have been done in carrying out the unlawful act and not collateral to it. It is not enough that the homicide occurred soon or presently after the felony was attempted or committed. there must be such a legal relationship between the homicide and the felony so as to cause you to find that the homicide occurred before the felony was at an end or before any attempt to avoid conviction or arrest for the felony. The felony must have a legal relationship to the homicide, be at least concurrent with it in part, and be part of it in an actual and material sense. A homicide is committed in the carrying out of a felony when it is committed by the accused while engaged in the performance of any act required for the full execution of the felony. Any person commits the offense of cruelty to children in the first degree when that person maliciously causes a child under the age of 18 cruel or excessive physical or mental pain. Malice is not ill will or hatred. For the purpose of this code section, malice means an actual intent to cause the particular harm produced that is physical and mental pain without justification or excuse. Malice is also the wanton and willful doing of an act with an awareness of a plain and strong likelihood that such particular harm may result. Intention may be shown by the circumstances connected with the offense. Determination of what is cruel or excessive physical or mental pain is to be made by the jury. A parent of a child under the age of 18 commits the offense of cruelty to children in the first degree when that person willfully deprives the child of necessary sustenance to the extent that the child's health or well-being is jeopardized. I instruct you that sustenance is food and drink which is sufficient to support life and maintain health. A person who, by concealing the death of any other person, hinders a discovery of whether or not such person was unlawfully killed, has committed the offense of concealing the death of another person. Unless the date is alleged as an essential element of the offense charged, the date of the commission of the offense alleged in the indictment is immaterial. In such a case, to sustain a conviction, there must only be proof to establish that the offense occurred prior to the return of the indictment and within the statute of limitations. The allegations in the indictment are within the statute of limitations for the offenses charged. The law provides that criminal action shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Gwinnett County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses must also be proven. Venue must be proved by direct or circumstantial evidence or both. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County, Georgia, did, between the 24th day of October 2013 and the 2nd day of November 2013, commit the offense of murder as alleged in count 1 of the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of count 1 of the indictment, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County, Georgia, did, between the 24th day of October 2013 and the 2nd day of November 2013, commit the offense of felony murder as alleged in count 2 of the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of count 2 of the indictment, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County, Georgia, did, between the 24th day of October 2013 and the 2nd day of November 2013, commit the offense of felony murder as alleged in count 3 of the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of count 3 of the indictment, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County, Georgia, did, between the 24th day of October 2013 and the 2nd day of November 2013, commit the offense of cruelty to children first degree as alleged in count 4 of the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of count 4 of the indictment, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County, Georgia did between the 24th day of October 2013 and the 2nd day of November 2013 commit the offense of cruelty to children first degree as alleged in count 5 of the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of count 5 of the indictment, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County, Georgia did between the 24th day of October 2013 and the 2nd day of November 2013 commit the offense of concealing the death of another as alleged in count 6 of the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of count 6 of the indictment, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no ruling or comment that the court has made during the progress of the trial is the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status for or against either party. One of your first duties in the jury room will be to select one of your number to act as foreperson who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. To assist you with that, ladies and gentlemen, I've prepared a verdict form. It's very simple. It lists all the 6 counts in the indictment against the defendant. Under each one is a check or an option, one for a finding of guilty and one for a finding of not guilty. You would simply record which one accurately reflects what your verdict is with respect to each count in the indictment against the defendant. It would then be signed and dated by your foreperson to be published here in open court. We do have 4 alternate jurors. We have Mr. We also have, for some reason, can't carry the case through to its conclusion, then you might be substituted for that person at that time. But unless and until that happens, he'll be held separately by our bailiffs in a different room while the original 12 jurors deliberate the case. I do want to mention to you that the items of evidence are going to be coming back to you for your use during the course of the deliberations. You might remember that during the course of the proceedings, you learned that some of those materials are hazardous, some of them are damaged, and some of them are falling apart, and that's why certain bags weren't opened. So I'm going to ask you not to open any of those dangerous things in the jury room. If you would like to have any of those things opened, you'd like to be able to examine anything that's in one of those bags that might be potentially hazardous, simply make a written request to the bailiffs and we'll open those things for you here in the courtroom under more controlled circumstances. You may now retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence that may have been admitted in the case. Mr. Bailiff, please take them out.
Bring your badge for that, please.
Our jury's out. You're welcome to be seated. Any exceptions to the charge by the state?
No, Your Honor.
Any exceptions to the charge by the defense?
No, Your Honor.
Would you please gather up the evidence, Mr. Porter, Ms. Jones, find those things that are appropriate to be presented to our jury for their use during their deliberations? Just a note for the record, there are some CDs and DVDs. I think there is one thumb drive, perhaps, that's evidence in the case. Those things can go out to the jury, but only because the jurors will not have any electronic devices that would allow them to actually play any of those things, absent making a special request to do so here in open court. If you would, please gather the necessary materials and prepare them for our bailiffs. We will include in the record as Court's Exhibit Number 2 a copy of the charge as given to the jury and as will be provided for their use during their deliberations. Thank you, ma'am.
I'm going to show the first box to Ms. Moss.
Yes.
I'm also, with the court's permission, to throw a bundle of nitrile gloves in case they want to handle it.
Yes. Please show those to Ms. Moss. Make sure she agrees those are the correct things to be sent out for the jury's use.
And we actually looked through and counted and made sure that we do have all of the items.
All right. And it is the garbage can under there?
Yes, it's
All
right
right.
here.
Very good. Mr. Porter, you agree those are the proper items to be sent back with the jury for their use during the deliberations?
Yes, Your Honor, and we have placed most of the items that are not to be opened by the jury in one box, which is this
All right. Thank
red
you.
and white box.
Ms. Moss, you also agree these are the proper items to go back with the jury?
Yes, sir, Your Honor.
Mr. Porter or Ms. Jones, would you add the verdict form, the indictment on which issue was joined, as well as 12 copies of the court's charge to that stack?
Yes, Your Honor.
All right, Mr. Bailiff, you can take that back to the jury. Thank you, sir. You can just put that outside the door and they'll gather it.
Yes, Your Honor.
Thank you, ma'am.
Thank you.
Thank you very much.